Okay, the first thing we need to do this evening is to designate a chair. All eyes go on to you. Okay, that's fine. Call the meeting to order. I'd like to read the open public meeting statement, or if you'd like to do that.
No, you're
Okay.
good. This is a regular meeting of the Fairhaven Planning Board. Adequate notice of the meeting has been given pursuant to the provisions of the Open Public Meetings Act. At this time of the board regular organization in January of the past year, the board adopted its regular meeting schedule for the year. Notice of the schedule was sent to and published in Asbury Park Press on January 6, 2024, Two River Times on February 1st, 2024. That notice was also posted on the bulletin board in Borough Hall and has remained continuously posted there as required by the statute. The copy of the notice is and has been available to the public and is on file in the office of the Borough Clerk. A copy of the notice has also been sent to such members of the public as have requested such information in accordance with the statute. Adequate notice having been given, the board secretary is directed to include this statement in the minutes of the meeting. Roll call.
Mr. Bordelon.
Here.
Mrs. Bush.
Here.
Mrs. Scott.
Here.
Mr. Newell.
Here.
Mr. Paolo. Mr. Ball. Mr. Nika. Mr. Anderson. Mrs. Antonin.
Here.
Mr. Bailey.
Here.
Mr. Fletcher.
Here.
Watch the stand.
Pledge.
Allegiance to the flag of the United States of America and to the republic which stands one nation, under God, indivisible, with liberty and justice for all.
Yes, there's any old business?
Do we have any old business to discuss? No, I believe so.
Okay, new business. Be the application of PB 2024-01. Am I pronouncing this correctly? Is it co-op? Four. Sorry.
No problem.
We take care of a couple of housekeeping things. If I can. All of your witness may ask them to stand. Our witnesses too. Prepared to stand, I'll swear over the end. Solemnly swear or affirm the testimony given before the board will be the truth, the whole truth, nothing but the truth.
Yes, I do.
Okay, just my general instructions. Before you start everybody sit down. Before you start testifying, state your name for the record, spell your last name. That way, because we're recording, if you have to have a transcript made of this, that transcriber will know who was speaking at that point in time. Okay? Second, for the applicants, folks, follow the directions of your counsel. We're going to take care of some housekeeping items first. So we need it smoothly. I have marked, with your permission, council, A1, the application of February 27, 24. Also the minor subdivision, A2. I think that's plan A. Minor subdivision, plan B is A3. These are both prepared by Insight Engineering, again, date of February 27, 2024. I also have our engineers report over the signature of Rich, PB1, our planners report, CCH, excuse me. The engineers report is 314. PB2 is the planners report for CCH over the signature of Mike Sullivan, that's dated March 15. I also received just now, or just this evening, a report from Insight dated 3/18/2024, which we will mark as A4. So if we have any other documents or exhibits to mark.
Just what's on the board here, we do have the survey.
Okay, survey, let's mark the survey as A5. What's the date of the survey, please?
1/2/24 looks like the field.
1/2/24. Do we have
What is the
copies?
field date? Hold on, let me need my glasses for this.
Do we have copies of that?
Be part of the packet. The only date on it is 1/2/24.
And so purpose, 1/22/24.
Yes,
Okay,
you want it A2, A5, I'm sorry, and the date on there is A5?
yes, please. And again, that's prepared by Insight.
Correct.
Okay, and we did not receive that.
No,
Okay. Any other exhibits?
You have here the proposed subdivision.
This is.
No,
A.
no, anything that we haven't already marked.
No, yes, the one behind that, you have, there's an aerial photograph.
Okay, aerial photograph, we'll mark that A6. Is there a date on that?
March 19th, 2024.
March 19, 24. And that depicts, I'll just have you describe that exhibit. Now I confirm, Sheila, that we have jurisdiction in this matter?
yes,
Okay, we have jurisdiction. Any other exhibits?
We have some photographs taken by the applicant that he'd like to.
Okay, how many photographs do you have?
I believe there are 5 copies of 5, each, so 20. There may be 4, there's 20 total.
Do 4 photographs.
4 photographs and then copies of those?
There's 5 copies of each photograph.
Okay, so we're gonna mark the 5 photographs.
4.
4 photographs, excuse me, as one packet A7. Can you represent to me that they depict various views in and about the property?
Did you take photographs?
I did, yes.
And
And,
the picture of the property, the
yeah, specifically
the application.
the porch, focusing on the porch section of the property.
And they accurately reflect the current conditions of the property?
That's correct.
Okay, so we'll mark that A7, 4 photos. Any other exhibits?
I think that's it, thank you.
I will advise you that we did receive a writing from, I guess, a neighbor. Sure, I'm just gonna mark this for identification. Make a call at this point in time. This is a writing, we're just mark for identification, not going into evidence. This is a writing as of March 19, 2024 from Leila Vitale, expressing her views on the application. One of the difficulties in this is that when you present certain evidence before this board, though the technical rules of evidence do not apply. In other words, this isn't, there's not a judge here to call it, objections or those types of things, but evidence has to be able to be cross-examined. And in this instance, though, we will mark it for identification as part of this record, and I'm going to share it with council. He can decide if he wants to have that come in. But technically, unless council agrees to it, because you can't cross-examine this letter, we should not be considering it, but I will give it to council, let her see, let her take a look at it.
I assume that whoever drafted it is not coming tonight.
Correct,
Yeah.
that's correct. I should have put that on the record as well. Let me share that with you. So that
Thank you,
this has not been given to our board members.
understood.
You may not have any objections to it. If so, we'll just read it into the record.
I have no comment. Am I gonna read it? Is it like it?
No, we're supposed to decide if we want the board to read this.
Oh,
They've seen this. I mean, I
I
don't think it
feel-
really means anything, so
But, yeah, so I'm really suggest.
Smell the smoke from here, John.
it's just confusing because it doesn't,
Right, because the hypertechnical gate really doesn't deal with the subdivision, which is what you're.
Yeah,
doing.
so
Spread some
I
things
think
on
it's
the-
confusing, so that, for that reason, I just. don't-
Okay, then why don't you put that just in front of your
Yeah.
table, in front of you at this point in time, we won't be
Okay,
If I can, let me just give you a little workshop quickly. The applicant this evening is seeking certain relief by way of a minor subdivision, one lot into two. Principally, the bulk criteria are, I believe they're all conforming, and it's a conforming use. It's in the R5 zone, okay? They are not doing a site plan, which is why I anticipate that you're not going to see proposed views of structures. It doesn't mean that you can't ask questions about what the applicant is planning to do, but really, we're just here is the subdivision conforming, and if not, what variance relief do or might they need? I do want to address one other issue because it was a topic, and I know sometimes this gets back to you because you've seen some of the planners' reports and you've seen some of the engineers' reports. This board is a board of limited jurisdiction, as you know. We clearly have jurisdiction to hear a subdivision. One of the issues that was raised was whether or not the applicant needed a relief by floor area ratio. Okay. If the applicant needed floor area ratio relief, that would be a D variance, and this applicant would be obliged to go before the zoning board of adjustment. In typical fashion in planning, we use some terms that sound a lot alike. We have maximum floor area. There's no ratio, maximum floor area. And I understand that they may need some relief with regard to that. That would be a C variance, just a bulk variance. In other words, that the total amount of floor area, and we'll have our professionals address it, exceeds what we would normally like to see. So they technically need variance relief. I will first let the applicant identify the relief that they're seeking this evening, and then let them have the floor. But I just wanted to highlight that for you because I know some of you get on the board. It's like when you start hearing, floor area, somebody just said floor area. What we're really talking about is the maximum, not the ratio. So we have jurisdiction to take a look at the question. Our planner raised the issue with us, and I believe we also have a writing from Insight that I believe the applicant will address. That was what was marked A4 that was given to me this evening. I promise I'll get out of the way, council. I'm going to get out of the way.
Thank you very much. Okay, good evening, everyone. My name is Brad Batcha. I'm an attorney. I represent Scott Core, who's seated to my right. He was sworn in a few moments ago. He's going to be my first witness tonight. Just to tell you a little brief overview of what's going on. My primary witness is Bob Hudak, who is a representative from Insight Engineering, and he's going to give some planning testimony to you tonight. So the one thing I just want to point out before we start is we submitted our application a little bit unusually. You might not have seen something quite like it in that we have a plan A and a plan B. But please make no mistake about it, my client's going to testify. We are seeking plan A. The only reason B was even there is just to give an idea of what we believe we could do by right. The goal here is to preserve the house that my client's lived in for many years and build a new house on the lot next to it. So with that, just want to ask the applicant a few questions. Could you just describe to the board, just.
Council, if it's easier for you, you can just be seated if you'd like.
Okay. No, I appreciate that. A little bit about your experience with the house and what your plan is here tonight.
So my experience with the house is I've been trying to move the family to Fairhaven for a number of years. We had actually tried to build a house around the block on 55 Foreman Street. Through no fault of our own, we were basically put in a situation where we did not have a place to live because of our builder. And basically this house saved the day for us. It's that simple. Anyway, I don't get emotional about it, but because we were able to bid in an environment that was very difficult to bid in, to be here in this town, as you may know, it's very difficult to compete with other buyers to acquire a property. We were looking at rentals. I'm a blue collar worker. I don't have the ability to really throw that kind of money away. We were able to acquire this lot through some help of a family. This house and this lot through some help of family, and basically it provided a place for us to stay. when we really needed it. And, the house is a nice house. It's not a little Cape Cod that needs, you know, that is straddling the lot line that obviously needs to go. I feel that it's a sufficient quality house. It's built well. We bought it from the original owners, actually. The original owners owned it before us from 1959. I believe she was 96 years old when she passed. We bought it from the estate. So, anyway, it's near and dear to my heart as far as that's concerned. I also think that it's in a unique position where it's on the side of the lot where this can happen and this does conform. And I believe that there is a good argument to be made that the house should stay and can stay and in lieu of potentially building 2 new houses and disrupting the neighborhood further. Not that I'm going to be building 2 new houses. I don't have the means to do that, but potentially that somebody else could do such a thing on this lot. So basically, that's the full disclosure version of what happened.
And before we get to the next question, let's get these pictures, they're already marked in.
Mark A7, these are 4 photographs, copies from.
Do you need additional authentication or what you did before was acceptable?
I'd like to put that on the record now that he's.
Okay, sure. So why don't you take the photos, we'll start with the top and just describe each one, and then we can hand them out to the members of the board so they can take a
Do
look.
you want to have them in the board's hands while you're?
Yeah, we can have some.
I think we're gonna be able to authenticate them.
Okay, yeah, I mean, I apologize for the last minute thing. I just felt like it would be helpful to get a visual of the house and specifically with regard to the.
Yeah, because I'm gonna ask you a question or two about the porch. I'd rather have them see the.
Sure. So
So again, you want to start with the,
the first picture here is
the picture of,
that's a straight on picture, facing east, looking directly at the porch from a Smith position, standing on the.
standing on Smith.
Smith,
looking
looking
at the
directly
home.
90 degrees at them.
Can I approach the Henry?
Sure.
Okay, picture number 2.
So, this is standing at the corner of Smith and Parker in a wide angle view, showing basically the frontage on Parker and also the porch as it relates to the rest of the house.
Okay.
So,
All right,
anyway,
next
and
picture.
these are just other shots. Somehow, I guess, this got lost in the sauce, but basically, other views of the same porch.
Is that the same picture?
This is the same picture. They're supposed to, I guess they printed, I asked them to print,
Okay.
things, but-
We'll just submit this.
Yeah.
Is that good?
Yes.
Okay. So, as a part of this application, we proposing one small modification to the home, which will remove a potential setback variance that we would have had to request, except that we're going to make the home conform. And that is, there's going to be a modification to the porch. So could you describe to the board that modification?
So to make this as presentable as possible to the township, I realized that the porch, as it stood, was an existing violation of the setback off of Smith. It's 23.7 feet instead of the required 25. So in the process of looking at this as a subdividable lot, what I'd like to do is basically correct that setback violation so that there's only one variance really being sought with regard to setback requirements on this lot. I also think that by adjusting the address from Parker to Smith, it would need an elevation change to make it look, to make it sit correctly, to put the front door there. And the way that the house is, that's a porch anyway, so it lends itself to that. It was actually a back door, that's why I'm confused as to, I thought I printed the other picture, I apologize for that. But there's a back door on that porch that can easily be made as ingress and egress off of Smith with the proper, when that elevation is changed off of Smith. So what I'd like to do is basically, if you could just imagine lopping off the required 1.3 feet to make the front face exactly at 25 feet and put the door in there and basically make it look like it's supposed to be that way. Another thing that I was considering, the reason why I didn't go any further with this, because honestly, everybody that I spoke to up to this point was like, oh, I don't know if they're gonna go for that. I was like, how could they want to rent this house out? It's a good house, you know what I mean? And they're like, As I said, what I said was maybe what we could do is we could change the roof line to make it match the rest of the house as part of the modification to that porch. If that was something that was required, I would be willing to work with the township on what they would, I'd be basically be open to suggestion there as far as what they'd like to see to let the house remain.
But your plan for the record is we're gonna remove 1.3 feet, make that the front door,
Yes,
and that would be therefore compliant with the front yard setback.
exactly.
Okay, thank you.
And just to be clear, that's the front yard setback on Smith,
That's right, of the existing home.
and that's 4
It's 25, right now there's 23.7, so there's 1.3 feet adjustment that the applicant has agreed to modify, so that will be compliant as part of the application. Okay, I'm gonna be bringing, our planner up to go through the engineer's letter and the planner's letter, but I think you wanted to, before I let you go.
Yes.
You had, 1 or 2 points, that you wanted to comment on with the engineer. So part of the engineering letter, specifically, paragraph 5, say that there should be new sidewalks installed, along the frontage of the park. And it should be ADA plan. I think the question you have is, since we did submit Plan A and Plan B, is this an engineering requirement regardless of which plan is adopted? I think that's a question for the town's engineer. That's true.
Yes, there were actually 3 different topics. Where we can
So let's do one by one.
I mean, we're a little out of order here, but you want me to jump in?
Is that
We're
okay?
here.
Yeah, I mean, if you feel comfortable, Rich, does it make more sense to start at the beginning though of your report?
Well, I
We
can
start
do
at the
that.
beginning, I'll ask the question, and then as we go through.
You want to do it that
Oh,
way?
that's no
All right.
problem.
If it's easier to
It's
digest
gonna be
that
easier.
way.
Yeah, just
We
the
did
family.
No problem.
Usually what the board likes to do is follow along. with the
Understood.
engineers.
And I completely understand this was a little different just because my client had asked, could we touch on these things? We'll bring him back.
Sure.
He's right there.
Yeah. He seems interested in the project.
But before we dive into this, the one thing I want to make clear, and I put it in my report. They did submit 2 plans. For purposes tonight, I reviewed the plan that has the existing house. I did not review the other plan.
I'm sorry, say again? The existing house.
Yes.
Plan A,
Planner.
which is really the one we have.
It's not labeled Plan A, but it.
B is literally a fallback, like if it doesn't work, by right, we could just have, 2 lots. empty.
Sure.
But this is, Plan A is really what we're here for. So thank you for that clarification. All right, so, next we're gonna have, Bob Kudek from Insight, who is a professional planner and will be providing, planning testimony. Have you appeared before this board?
I have not appeared before this board, however, I'm a licensed professional planner in the state of New Jersey. All my licenses are current. I've appeared before numerous boards. In fact, last night it was in Roselle Park. I've appeared before in Monmouth County, numerous boards, including Eatontown, Oceanport, Long Branch, and Middletown, most recently.
And you'd be presenting him as an expert in what area?
Planning.
Planning. Have you ever failed to qualify?
No,
Yes, fine.
Can we accept him as a planner?
Yes.
Okay, thank you.
thank you.
So have you reviewed a copy of the borough engineer's, report regarding this project?
Yes,
Okay, so can you take us through the comments? Some of them indicate, testimony is required and others have just some questions that I think deserve a response.
okay, I think, I'm gonna go through it systematically. Again, I'm not an engineer, I'm a planner, so it's a little bit different with the engineering report. But I'll start at number 1 on page 1. We talk about the 2 plans, we've already discussed that, we're looking tonight for Plan A, not Plan B. Item number 2, the plan indicates the front door of the existing dwelling shall face Smith Street. As you've heard from the applicant, we are proposing making a change there, that's an existing non-conforming situation here on this property, we're making it conforming, so we're limiting any kind of relief we would need for that item.
Just maybe add a little information why that's gonna become the front yard because of the way the.
Because of the ordinance,
Yes.
because of the ordinance, I was, again, my planning testimony talks about that, but no. Rich, since you brought it up. So I'm gonna go to the survey right now. This is the existing lot. This is A5. This is the existing lot. It currently fronts on Parker Street. And the reason this is because the ordinance states that it's the shortest front yard, actually, because you actually have two, because any yard adjacent to a street, it qualifies as the front yard. The front yard is on Parker Street. Parker Avenue. I apologize for that. One of the comments later is about correcting this, which will be corrected. So currently it's on Parker Street. When the lot is subdivided, as you'll see in the plan for this project, which I'll go to now, actually, the shortest street frontage becomes Smith Street. Therefore, this property will now have a Smith Street address. As we will see changing the address for the property as well from Parker to Smith Street with the post office. And obviously, the interior lot will also have a Smith Street address. There was a question, which I'm kind of jumping out of order here, about front yards, the actual front yard setback, whether it will be prevailing or not. We did do a study. The aerial came out terrible, so I don't have it with me. You could not read it unless you had a magnifying glass. But essentially, the only properties that would qualify as counting towards the prevailing lot coverage or the prevailing front yard setback are these several properties here. And then one property, or these two properties here on Smith. The prevailing front yard setback on Smith is 21 feet, it's 23 feet. I apologize, 23 feet. And on Parker is 21. So we show a 25-foot front yard setback, which more than qualifies. Item number 4 concerns the curbs and sidewalks. I don't think we have any issue with complying with that. Certainly, there are new curbs and sidewalks along Smith.
We've had three
Oh.
up there too, just a minor one, but.
Oh, the copy of the will serve letters? Yes, yes. They will be, and the utilities for the new building will be, the new structure will be underground. Item 4, again, the curbs and sidewalks, we will comply. Item 5, again, as we mentioned, it will be required regardless of whether or not the subdivision plan A or plan B occurs or is approved. I understand there's some cracks actually in the curb or in the sidewalk, I should say. Regarding number 6, our client will actually get a tree removal permit. I don't think there's any issues with that. We have no problem complying. Number 7, as I understand, the property has been on municipal water and sewer for quite some time.
Can we go
Yeah,
back up to 6 and just
6,
walk
yes.
us through the history of that a little bit and
I think
the
the
work
owner.
we've done to file a permit at this point in time,
Mhm,
for the paperwork matter, but
I know. I think the owner can speak more of that than I can.
Did you file a permit?
This is concerning the trees, the removal of the brushes and,
So what had happened there was, this is on the north side of the lot, the neighbor, STF Consulting, the business, at STF Consulting facing Foreman. He was looking to install a fence, a new fence, because the fence was being engulfed basically by the brush that was there, it was like an uncontrolled brush situation. We were actually away for a few days, he tried to reach me, I was unavailable, so he just opened up like a, I don't know, 6-foot swath going all the way, it needed to be done anyway, it was a mess, really. I didn't even actually know that there were trees in there until we finally got it all the way down to all the poison ivy was gone and all the roots and the weeds and everything else. I don't know if we have an area that show.
Hey, show it. I mean, this is.
It's in this area here.
Unfortunately, the yellow, the orange.
Yeah. try to
But
put that
basically,
state.
the northern, in this area, as much as 25 feet of the northern section and closer to maybe 12 or 13 feet here. But the whole section of the property was compromised. This tree still remains. There were two, to your point, Rich, is, there were two trees that were buried in there that were I guess either dead or dying and covered in poison ivy. So when the neighbor cut the swath of 5 or 6 feet, I had my landscaper, I said, listen, can we just clean the rest of this up? Because it looks like
when
garbage.
did
And
the
then
call done? Just to give us a time frame. This year,
No,
last
probably,
year?
probably last year. Probably, whenever he installed the fence on Foreman. It's a Foreman, that Foreman corner lot, whenever he did that, it was right after that, because actually, the guy who did the fence work for him, Wilson, he was the one that did the landscaping, and that's the guy that was cutting the grass for me as well. So I said, hey, could you just clean out the rest of it? And there's a little bit of a language barrier between myself and him. And I didn't even realize that that would become an issue. I didn't even know that, I mean, once we got it all cut back,
Have you
I did
subsequently applied for the permit for that?
for that, I did not, no,
Okay.
no, I did not. That was my error. I'm not gonna sit here and give you a different story. That's what happened. That's how it happened, and
But to the extent that you need to apply for a permit so we can get our paperwork in order.
absolutely,
No, no,
whatever's required, whatever
And
is
just,
required.
just for purposes of this
Yes.
record, and I don't need to step into your counsel. But the document that you were referencing for purpose of the record is A6. The applicant was pointing along the dotted yellow line in the shared property line between himself and the property owner to the, because that's to the northwest,
So.
to the north.
To
To the north. Thank you. Sorry.
Thank you.
My apologies.
So we will comply with that condition as noted by the applicant. Item 7, and again, the property owner can speak more of this. As I understand, the survey, the property hold survey depicted a septic and dry well. As I understand, the property's been in the, again, the property owner can speak more on this. The property's had city municipal water and sewer for quite some time. We didn't have anything on our records of any kind of septic system. Again, you know,
In my report, as you saw, there's a, that was an old survey we had on file with the borough.
we have-
I'm really bringing it up to your attention because if this gets approved and a house does get built next door, they may find this.
We have to deal with
And
this.
you have to
Sure.
deal with.
You'll have to deal with it,
We
absolutely.
get a copy of that, I guess.
Yeah, we have a
it's in
copy of
there.
it.
Okay.
We have a copy of the report, which we appreciate.
But again, just so the applicants, generally, as a condition of approval, we want separate services to each one of the lots. Is that going to be a problem to do that?
No,
We're talking about separate.
no, first of all, this was a historic old system that just might be stuck in the ground. But the existing home has public water sewer and the new home will have public water.
But your office hasn't probed around to see if.
No, it has not.
There.
No, it is not.
It's just a matter of digging it up at some point and getting rid of it.
If it's still there. Like I said,
If
we
it's
found
there.
paperwork that shows it, so.
And again, it was arguably 40, 50 years ago when it was connected. So we have no record of the connection, no idea what happened at that time. Okay. So we discussed the dry well, provided on each of the lots. That would be required regardless of whether we went for Plan A or Plan B.
Now, would that be, subject to, the new construction clearly needs that? Would the existing home need it if there was a grading plan that showed there was no runoff because it's an existing? Would that be subject to a dry well necessarily? Would it be to the,
I'm asking for it because it's part of the subdivision. It would be nice to capture some of that roof runoff.
okay,
Yeah,
could
I'm
it
not
be to your
sure.
satisfaction if we were able to show that?
Yeah, we could make it to my review and approval.
Okay.
Subject to my review and approval.
Just so that you
For
understand,
the
generally,
existing
generally,
home.
the condition of the board is that, you know, dry wells should be located on each of the lots after consultation with the engineer. And the board may have some questions.
Okay, and so my comment was strictly to the existing home?
Exactly.
Not to the proposed new construction home,
I got you.
but thank you.
So that if down the line, the engineer says, okay, I agree with you, it's not going to be needed, that's fine. But if he says, no, it's going to be needed, I
Understood.
don't want to surprise him.
Yeah, that's the language we're
Okay,
expecting.
very good.
Number 9 is a mea culpa. It will be corrected. Number 10, and again, the property owner could probably speak better about this issue than I. But the ownership of the various fences. As you indicated before, there was some activity there, I believe. The neighbor put up a fence, is that correct?
Yes, referring again to the aerial,
A5,
A5, turning at A5, the north.
I'm sorry, A6.
A6, the northwest corner, this STF Consulting, when he installed that fence, I know that he owns that fence, obviously, because he just installed it. The white aluminum fence that starts at the northeast corner and runs south and then over to the driveway of Parker. I believe that's ours, but it's very old. It's in decent condition, but I believe that's ours. And then I believe, although I'm not sure, the only thing I'm unclear of, the section of fence, it's a green chain link that runs between, for lot 1.01. I believe that's his, I'm sorry, I believe that's 1.01 rear yard fence. I don't believe that we own that.
Survey shows.
The survey,
Line.
yeah, I was gonna say, both. The survey indicates that the fence, I guess you want to call this the eastern property line, that appears to be on our property. The chain link fence along the north, along lot 1.01 appears to be on their lot. You indicated that this is the new fence, it clearly is on lot 1. And I'm referring to A5 the survey. See the fence
Yeah,
here?
it indicates within a half foot,
Yeah.
a couple inches, so they're basically right on the line.
But the only fence that would be ours would be this fence along this
Easterly.
easterly property line, correct?
Okay.
Alright.
Does that answer your question?
Yeah, it's better get this out of the way now before things start under construction and then the buyer of the house wants to replace the chain link fence or whatever the case, and then nobody knows anything, and then we're stuck dealing with it, so,
You don't want the phone call, which I totally understand.
yeah.
So now let's move to number 11 at this point. Again, we spoke about the grading plan. And that will be required regardless of whether or not we go with Plan A or Plan B. And we're fine with that. Number 11B with the no letters of no interest from Freehold Soil and the Two Rivers Water Reclamation Authority, we have no objection to that. Again, 11C, objection to ensuring that the right-of-way permits are obtained. 11D, obtaining tree removal permits as necessary. Absolutely, it appears on, if I may, on the proposed new lot, there will be a tree that needs to be removed. Again, that will be when, at the time of construction, permitting, I should say. 11E, the payment of the tax map revision fee, no objection there. 11F, complying with subdivision notes. Is there a specific note that's concerning to you? Is there anything specific on that one? Before we go on?
Proposed tax, yeah, well, you're basically saying you're gonna file by deed. Talks about the survey, it talks about. I think it said something about property corners. To establish as a field, the tax lot numbers to be approved by tax assessor. We talked about the front door because of the dwelling facing Smith Street, and then there's a common reduction of trees. So rather than regurgitating all that, I just reference your general
Yes,
subdivision.
okay. Are we good on that? This time? Or do you want me to go through? in more detail?
No, I'm just basically saying that you need to comply with those notes and do the work that's performed as indicated.
Yes, yes, we're agreeing to that.
Just one other thing, I don't know if we covered in enough detail, maybe the engineer could weigh in on this. You mentioned that there's gonna be milling and paving on Smith Street, and so I think the applicant was interested just to know if there was gonna be any particular deadline, what's required specifically from the applicant there, by way of that comment for. Does it have to be in by a certain date? Do we know when this work is happening, and what would the applicant have to do vis-a-vis that works.
So yes, the borough this week, or actually today, just completed all the concrete work out there. We are in the process of doing the restoration. Sod was delivered to the borough tonight. We're gonna start sodding all those areas that are disturbed. And then eventually we're gonna have a mill and paving crew come in. Most likely not for a couple months or so, early summer. So the one thing we want to stress is if the subdivision gets approved, you need to comply with the street opening ordinance. The street opening ordinance was recently revised. It will still fall under a road moratorium, but there's certain steps you need to take. And the problem is with a subdivision, you can't stub out your utilities at this point in time. The utility companies, they won't all allow, like the gas companies will not put in a meter or a stub for a meter until a foundation's in the ground. So you can't say, all right, I'm gonna get ahead of it and bring everything into the property prior to the borough milling and paving. What we can do is I can try to hold off the milling and paving and do this street. We've got, 40 different locations throughout the borough, give or take. So we could schedule it so I can, hold off as long as possible.
And that's exactly what I was, looking to address. We would look to work with you to do it as quickly as possible, so that I'm like a perfectionist when it comes to that. I hate driving down a block, and then if you see like a patch, you're like, they just paved the street, like, I don't wanna see
You know
that.
what? Actually, the water company's gonna be doing the paving. Because,
Okay,
so the water company put in a new main last year. As part of the coordination efforts, we were able to get this road in this year's road program to put in all new curb, sidewalk and ADA ramps. So then we can mill and pave, the water company, utility company will now come in and mill and pave, which is in accordance with our street opening ordinance, and you'll have a brand new street.
Okay.
They're waiting for us to finish other sections of the borough.
Okay.
But they are anxiously, in fact, I did receive a call today from them to see where we were with everything. So their subs are lined up to get the milling and paving done. You're right, it's tough to see a road get opened, but we're gonna have to figure it out, and work through it.
I
So,
mean, we'd be willing to do it, I guess, anything on our end to expedite the process to make it a clean sweep for the new road.
yeah,
With regard to the new law, basically.
Right.
you're really looking at, you need to tie in water, you need to tie in gas.
Right.
And oh, and sewer,
And
yeah.
sanitary.
But you're gonna have separate lines for everything.
You can probably get sewer. You're gonna have to go to them anyway to get your approvals. You could talk to them about trying to get ahead of that. You can talk to the water company and see if they can at least set a meter pit, stub it out. The gas company is the one that you really keep it, for safety reasons, you can't do that. And, based on the rules and regs.
But you don't have an exact date when the paving is gonna occur, you don't believe.
Now, I could say this summer, which will be here before we know it, so
But that could be June, it could be,
let's just keep
August.
the communication open. Take a look at the ordinance, see what the requirements are, and we can continue the conversation.
that's fair,
Okay, thank you.
that's very fair. I think that concludes your memo, Rich. I don't think there's any other items you have, unless you have any additional questions, please.
The only other thing is, I didn't mention it, but on the plan, they show that they're gonna be, they're proposing a site triangle easement. So that
I think they did mark it, did
they
they?
marked it, so we would just need a description.
Yeah, mark it on here.
You need to meet some bounds.
Description of,
Yeah, we'll need a meets and bounds,
Okay,
along with the deeds, obviously, for both lots.
okay, so I think the next thing we're up to is, you want to address this first?
Yeah, we'll start with that.
Okay, so earlier we marked into evidence, I think it was A4, a supplemental letter that was prepared by Insight and circulated to the board.
Yeah.
So could you discuss why this was drafted and maybe just go over the numbers a little bit?
Yeah, essentially, there were two reasons. One, in light of conversations with your board attorney to discuss whether or not the variance qualify as a C variance or a D variance. I think your attorney did a fine explanation of that. So I'm really gonna jump into the second portion, which is the floor area calculation. We use the assessor's card and the calculations for the principal building. And it's clear that you're over the cap, but you're not over the FAR itself. The FAR requirement in the R5 zone is 0.4. Currently, we're at 0.2. And if the subdivision is approved, the existing house will have an FAR of 0.38. And that's actually rounding up a little bit. So we're well within the FAR.
What is the cap?
The cap is 2,200 square feet. So we're at around 2786.
And just to clarify, that 2786 was kind of a generous number based on what the assessor had based on the exterior of the home. And it also includes, based on the new version of how you define square footage, the basement.
It includes the basement, the first floor.
552,
Yeah,
and a portion of the garage, which was 336.
correct.
So without those two, I believe the assessor's card which I've attached, is attached to this, is 1898 of livable.
Yes.
So, it's a modest house.
When you factor all that out, that's correct.
And-
But it's a split level house, so a portion of that basement is above grade. And so under the current ordinance, it would be categorized as part of floor area.
Right, so that's the relief that we're seeking, which is a C variance, where according to calculations, there's 2786, where 2200.
Correct.
Thank you. Any questions on that from you guys before we move on to the planning letter? Okay.
Can I ask you a question, Mr. Chairman?
Sure.
Temporary chairman, may I ask a question?
Don't worry.
For the record, I'm Michael Sullivan with Clark Gate Hits. I'm your planner, so it's nice to meet you. I have a question, regarding the house, and there's been discussion about switching the entrance, the primary entrance to Smith Street, to avoid the technicality of the variance that it would exist there. What remains on Parker Avenue? What does the house look like on Parker Avenue? Will there still be a walkway to a door? Will there still be a door? What does that look like?
That would be effectively the side door.
So visually, there's no change.
Right.
There's no change to the facade, there's no change to the walkway, it essentially looks the way it does today.
Correct.
What would the change look like on Smith?
And that modification, there's a couple, I'd be willing to basically work with the town on what they want to see, but basically, as long as it's brought into conformity. I wanted to make it look aesthetically pleasing, so we have to resect it by 1.3 feet. What I would like to do is, I would like to make that roof line match the rest of the house, so that way we're on the same elevation. And you can enter through the front door on Smith, and it wouldn't be as much of a break in the from the main living section of the house to the other. I'm really, again, when I approach this, everybody said to me, they're not gonna let you do this, you're not gonna do this. So frankly, I'm an average Joe, really, when it comes to this type of stuff. I didn't want to go down the hole of basically spending money on plans where they could potentially just be thrown in the garbage. You know, I didn't want to do that. This process is expensive, as you know. And I'm basically open to suggestion here where we could work with the town and get something that's gonna look right, and we can go back and forth. And
From a planning perspective, do you feel like it's essential to move the door there or not?
No, I guess when I look at this is an existing house, in an
Yeah.
existing neighborhood, at a scale that fits the neighborhood.
Yeah.
All the mass of the house is pushed back to the back of the lot, and it kind of comes down as the split level does towards the street. So when I look at it, I would feel that if the door were removed and the walkway removed from Parker Avenue, that might look odd,
Right,
because that's where it's.
and I don't think that wasn't your
Right.
plan.
That was my only question is,
Yeah.
are we gonna create something that's, out of sync with the neighborhood, just to,
For all intents and
To do
purposes, it's
with
gonna look the same with this, bringing that back a foot, 1.3 feet.
Okay.
Unless the board feels the way it looks now is okay, they would need to grant a 1.3 foot variance, and I think the applicant would be okay leaving it the way it is.
Speaking completely frankly, I wanted to keep the house exactly the way it was. I didn't want to do anything. However, I acknowledge the fact that there was another variance here on the side, and I didn't want to stir the
We had an
pot.
ability to cure it easily
I
by pulling
really-
it back 1.3 feet, so that was the decision that was made. But if we're hearing suggestions that that's not necessary, and the board was inclined to grant a variance, that's also an option.
But are you? If you kept it exactly the way it was, is there going to be a higher elevation above that porch? So it's pre-existing without any modifications,
No,
and there's no exacerbation by going to second floor or anything like that, you're gonna leave the house as it is.
Yes,
And that even goes to the point of, I shouldn't even, I'm just gonna bring it up anyway. I mean, I think I saw somebody cringe when they said, well, it's been 65 Parker for 65 years, right? And then now it's gonna be something on Smith. And is that necessary? I'm willing to do whatever I have to do to save the house. Is that necessary? That's up for to you guys to determine, basically.
But let me ask the question to our professionals, that would be a design waiver then, as opposed to a variance, or is that in our zoning section?
It's gonna require a variance.
That's gonna require variance because it's a front yard setback.
but it's on a corner, isn't it?
Correct, but it's two front yards under the ordinance, so it would require, and it's a new lot, so it would require variance relief for that.
Well, it required two front yards before,
Correct,
so that's an pre-existing.
We already
condition.
had
Now I'm
two
asking-
front yards.
Now you're putting a lot line down. And I'm
Correct.
asking the professionals at this point in time. That's still an existing, even though you now have two lots, but I'm saying, I'm focusing more on that aspect of our ordinance, which says it's the short that require, is that in our zoning or is that a design?
It's in the zoning.
It's in the zoning.
And
Okay,
for the purposes application, the rear and side yards flip.
that's correct.
correct.
So that's what's triggering this discussion on having a Smith Street address and that becoming basically the
Gotcha.
front door.
I was just trying to see what the lift,
But-
I was just trying to see what the lift was.
Encroach into the front yard
Right,
setback
I
as
mean-
well, which is pretty.
But is that speaking to the address or the front door itself? Just the address, right?
Front door.
Well, the front door as well.
The front door, as well, 'cause it would have to face that street. Okay. So,
That's the way the front yard.
so then I think we'll keep it,
We'll amend our application to include that as a variance.
it really, as you can tell, the applicant,
Why don't we hold off at this point?
let's hear what the board weigh in on things. But we're happy to.
You don't have a yes yet, so.
I agree.
And again, I'm not trying to jump the gun on anybody, I'm not trying to upset anybody, but I'm just saying that can be a topic for the board to discuss with the recommendations from our planners and the engineer.
But just to end that point, the applicant is open to both versions of that. We might seek additional variances if that would be.
Thank you.
Does leaving that additional, which my calculation is like 21.32 square feet, is that gonna affect your? I was just running the numbers, your memo.
It's not really gonna affect them very much. We're actually under the 38 number, yeah, our FAR is somewhere in the range of 37.6,
Yeah.
37.7. So we rounded up, obviously, so 21 square feet is not gonna matter at all.
Okay.
Okay, thank you. So do you want to go through, Mr. Sullivan's letter first? Do you want to go-
I mean, essentially what, all the items that are brought up in Mr. Sullivan's letter, I'll go through with my testimony on
Okay,
planning.
that's fine.
If that works for you, I totally, but again, we kind of made my case already.
If we miss anything, we'll hit it.
So I'm gonna try to truncate this a little bit because I had a lot of discussion on what we're doing here, but I think we really understand at this point, what we're looking for is we're looking for two variances with respect to what would be the lot 31.01. where we have a variance relief for, well, now 3 items. I'll include the front yard setback. And I'm referring to the proposal, which I don't think we marked, I think it's already in evidence. We're looking for the cap, if you will, we're above the 2,200 square feet floor area that's required in the zone. That's an existing non-conforming condition. At this point, we're not looking to change that. We're looking to keep the house as is, as you've heard. So we're looking for a rear yard setback variance because, as your engineer pointed out, the lot changes. Through this subdivision, this becomes the front yard, and what was previously a side yard would become a rear yard. Therefore, we'll need to seek relief for the rear yard setback.
Which would be what required and what is.
So the requirement is for the rear yard setback is 30 feet. We're at. Hold on a second, let me. 18.8. Yeah, it is 18.8. Which is the existing side yard setback, current. Again, we're not changing anything here. And then the front yard setback was 24. We said it was 24 and change.
It was
23.7,
23.7.
I take that back. I stand corrected, 23.7. So those are the items we're seeking relief from. You also talked about street trees as well being a design exception. So as noted, the lot is around 7,000 I'm sorry, get my math correct here. We'll have 2 lots. Each lot is conforming. Lot 31.001 will be 7,382 square feet, where 7,000 square feet is required minimum for corner lots in the zone. Proposed lot 31.02 will be 6,654 square feet in area, where interior lots require a minimum square footage of 5,000 square feet. As noted, we're looking to keep the existing house on the lot. So with respect to the borough's code, as noted, we're changing, essentially the lot lines will be changing from what was formerly a side lot line will now become a rear lot line. And that's essentially why we're here tonight, seeking that relief. And go into the C1 variance at this point, the hardship variance. I'm sure you understand that variances under this criteria are typically granted when relief must be based on the exceptional narrowness, shallowness, or shape of the property, location of legal existings thereon, or other exceptional situation affecting proposed development that results in practical difficulties or hardships. In our case, I would argue that it's an existing house. Respectfully, we want to maintain what is existing. Again, we're not exceeding FAR, but we are exceeding the cap. It's currently exceeded. The house was built in approximately 1959, well before the cap requirement was required. There's just practical difficulties with changing the setbacks. They are, again, the subdivision itself is as of right. To do that, in order to maintain what's existing, we would need the relief. I would argue under the C2 criteria, that known as the Flex C criteria, the positive versus benefits. I'd argue there's actually a stronger argument there because it keeps the existing streetscape. It keeps the house intact. The existing dwelling has functioned for a long time, as you've heard, without incident. And really and truly, the existing setback, whether you call it a rear yard setback or a side yard setback to lot 30, which is the adjacent lot here, will not effectively change. There is no change at all. So they're not going to see a change in what they're currently seeing. Further, there is, this will further the aesthetic purposes of zoning, in my opinion. It'll keep that consistent streetscape. The neighbors won't notice any real discernible difference with respect to that setback. Keeps a desirable visual environment as well. So it's my opinion that the benefits of keeping the dwelling on the lot outweigh any detriments. I really don't see any detriments because there's nothing really changing at all here. And with respect to, I know there was a question about street trees. I mean, there aren't many street trees to my knowledge in the area. And really the standard for design exception is reasonableness. And I think reasonably to add additional street trees would not be necessary. Of course, any variance cannot be granted without satisfying the negative criteria. That the proposed plan will not substantially impair the public, or substantially, there will be no substantial detriment to the public good, and the proposal does not substantially impair the intended purposes of the master plan or the zoning ordinance. Again, this house predates the cap on floor area. There's no real substantive change. I noticed taking a ride around the neighborhood, there are a number of houses that are actually larger than this house. So I don't think there's any change really, or anything that's going to affect the zone plan, if you will, or the existing zoning for the lot. I think the modifications that we're proposing here, the subdivision, again, that's in line with what's permitted under the ordinance. So I don't think there's any detriments really to this application that I can really speak of. So essentially, that's my testimony.
Okay, thank you very much.
Can I ask a couple questions?
Yeah,
So, how large is this lot relative to the other lots in the zone in this neighborhood?
This lot is more than double those lots. The existing lot, you mean?
Right.
Yeah, it's 14,037 square feet. And and again, the corner lots require 7,000 square feet, and interior lots require 5,000 square feet minimums.
So in terms of appropriateness of scale and density, from a standpoint of this, the subdivision in addition of a new dwelling unit or a home, and this would be consistent with the neighborhood fabric.
Yes,
And in terms of the purpose of the zoning, which call for the appropriate uses in appropriate places, this is an appropriate place for residents.
yes, it's single family zoning will maintain the requirements of the zone.
And in Fairhaven and in general in New Jersey, is there a need for housing? For homes?
Yes, there is. Yes.
Thank you.
Are there other questions?
Any other issues with
I don't have
regard
any
to the
other
planner's
witnesses.
report?
I don't think so.
Any other points?
I think you covered most of them. I think the only issue that I saw was glaring was the trees, but that was it. And again, it's a design exception based on reasonableness, which I think, again, as you know in your report, there really aren't any, and adding them, what are we really adding to?
No, I mean, I'm a landscape architect too, so I think trees are good, so. I'll let-
Yeah, I mean,
I'll let the board
it's-
decide on that.
We noted on our plan that we would be willing to add them, so if it's something you want to add, we can certainly.
There's two aspects to that. There's the easement that's required and the trees that are required.
Correct.
So, and which trees are you taking down? We asked the question and, you know, we've got a 42-inch oak tree in the middle of the site. We've got a sycamore that looks like it's about 24 inches, up close.
I'll let you answer that question because you have more knowledge of what
The little one's not important to me.
you're talking about these trees here on the existing lot. More than likely,
When I would ask you to verbalize where you're pointing to on the exhibit.
A5. I'm gonna let you answer the question though.
And if you want to mark it, you can mark.
Do you
that
want to
also.
mark it on there?
I mean, if you have a highlighter or
Or red pen, that might go through as all red marker.
So on
I have a
A,
highlighter.
on A5, the only tree that would need to be removed, and that would be the one we'd be seeking to remove, would be within the building envelope. The 42-inch tree marked 31.12.
That's 42-inch oak.
Yes, that's correct.
And so in terms of protecting the sycamore, which is closer to the sidewalk there?
This one here.
No, it's closer to the existing home. There was-
Over here?
No, on the new lot.
This one here.
Yeah.
Yes, close to the front. Are you able to, I mean, I would recommend as a condition of approval that at least that tree be protected and through construction, and it's still got 50, 60 years left.
Can you pin this one up in the front? there?
This one here.
Yeah, I mean, I wanted to keep it so that, with regard to the other lot, that it was all built to conformity according to what the town is looking to accomplish. I have no plans to remove that. I think we can work around that, so I would be open to that. Yeah, I mean, I think the only tree that I see that really needs to be removed is this one.
So the purpose of the record.
Sorry.
Oh, the 42 would be something that.
The 42 oak would be the one that's removed in the center of the property.
The one we would like to keep, or you would like to keep.
That one would be removed.
The planner had asked about the sycamore.
The sycamore, this is the 16-inch sycamore, right? This is 16-foot sycamore, right?
The reason I asked about,
I'm just trying to get the description. I got sycamore.
Okay, so the
What size?
sycamore is a
16 feet.
16 inch? or
Thank you.
16 feet.
16 feet.
Okay.
I thought we were measuring the base, but I guess we're not, all right, so
All right.
16.
Yeah, I thought the planner had said 24.
That was,
No, that's-
that was an estimate.
Oh,
It's labeled here 16-inch tree. Is that the big?
Is that-
the
is that
base? It's the diameter of
That's
the.
the caliper.
The caliper of the tree, 16
Diameter breast study.
Okay.
Yeah, so the 15-inch one here. Is the one we're talking about.
I mean, my intention was to, and again, we have to look at this further, but my intention was any new dwelling would be a north side driveway. So to your point, I don't see why that would have to come out.
so we're in agreement with this.
Sure.
Any other issues from our?
I don't think I have anything outstanding to report to the comments. That form was covered.
Any further presentations, I guess?
We don't have any more witnesses or presentation at this time.
Any questions? If I could, any questions from the board? Would you call them?
Yeah, anybody, questions, comments?
I have some concerns about the trees that you've taken down and are proposing to take down. And I find it a little bit unsettling that you just went and took some trees down without going through the proper channels. And I am not sure, we can't grant you a variance for taking that tree down that you want. You're gonna have to go through the right channels to get permission to take the tree down. You have to go through our tree expert. And there's no guarantee you're gonna get permission to take that tree down.
The other, we don't have as you correctly pointed out, we don't
Yeah.
have the jurisdiction in terms of, from a planning perspective, and I think from site plan, I think you have a right to know what he's proposing to do and make comments on those things. We certainly don't have the right to grant you a tree removal permit, and there may,
Nor, we're not seeking one.
yeah, and you're not seeking that relief, but
But you're going to have to.
Understood. That we would have to apply, and I think the record reflects we'd have to apply for a permit for the removal of the one tree that, in the applicant's opinion, would need to be.
Will that tree, that we're talking about in the back to 42-inch street, will that be on the new lot, the proposed lot?
It is on the new lot.
It is on the new lot?
Yes.
Okay.
Well, they're both trees are on the new lot, right?
Correct. Both the ones we're talking about this evening are on the new lot.
And there's a tree north of that as well?
There is another tree, a little bit to the north shown on there.
Yeah, I'm assuming that stays, like you said, the driveway
That
most
stays.
likely will be north of that, so maybe that tree stays as well, right?
Yeah, I mean, there's enough room there to
Yeah.
put the driveway. I'm looking to disturb, as you can see, disturb the property as little as possible. I can't. That one bit that we're discussing, that large one, unfortunately, it's got like root structure that goes like, it's very, very large. So, that's the only one that I was really looking.
Is that the
to
oak?
disturb. That's
The oak.
the oak, yeah.
Let me comment on the board with that, you'll see independent.
Independent for that, yes.
any other questions from the chair?
Yes. I had a question about the dry wells. There is a long history of flooding on Smith. So, unless there are dry wells there, I do not see how, and dry wells in the existing and in the proposed. I think, there's already a problem, and I would be very concerned about, putting more hard surface in the area, so that will be less surface for the water to percolate down. So, yeah, I would really say that you would need to put dry wells in both the existing and of course the new structure would have that.
Okay.
And Rich can speak to that, the flooding on Smith, we've been working with that for years.
I also have a question about the fencing. You indicated there's 3 different fences on the property, but you're not quite sure who they belong to, at least one of the fences.
I mean, I believe firmly that.
Can't believe.
The,
you have to
But if you
believe.
move, I deal with this every day when clients are buying and selling homes. People don't know whose fences they are. We know if they're on their property or not, but unless you have some ability to look back to the person who constructed it, sometimes you don't quite know. These fences are all within inches of the property line. We can tell you based on the survey that the fence along the northern side is on the neighbor's property. So you would argue that that's that neighbor's fence, but it could have been mislocated by the applicant who was installing a prior owner. You know, if you put it in yourself, you know what you did. But sometimes if it's the type of fence that doesn't face the right direction, like, you know, the nice part faces the neighbor. But when you're dealing with a chain link fence sometimes, or stockade fence, they're pretty much the same on both sides, so sometimes it is difficult to tell.
And ma'am, to your point, that fence in question, the pretty side does face me. And it's also an older galvanized chain link fence that predates that owner and myself, so I believe that that's the case. I really have no way to confirm that.
So we suspect it's the neighbors because of those two reasons, but we don't have any personal knowledge of how, you know, who installed
Do you know whose property? Is it on
it.
your?
It's on the
property?
neighbors.
Well, it is on the survey.
By a couple
Survey
inches.
does show where they are located.
Right,
Who put it up, we don't know.
right. but
So the one on
I
the
think it's
north
more
side
important whose
here-
property it's on.
So this one is shown on the survey that it is on the neighbor's property by 0.56 inches, half a foot. And they don't actually have a reading here, but you can see just by looking at it, it's over, oh yeah, 0.8 here and 0.7. So it's on the neighbor's property.
Both fences in the rear, and as I understand, the neighbor in lot one did get a permit.
Just for purposes of the record, just give
Maybe
me a
not.
direction.
Hold on.
Give me a direction as opposed to a rear.
Sorry, along lot one on the northern,
Property line.
rear lot
The
line.
north property line, the fence on the northern property line is on the neighbor's property. Both the chain link and the vinyl fence.
And then the third, this is on the eastern
The
side.
fence on the eastern side is on the property line for the most part. They don't give a distance off, so it looks like it's pretty much right on the property line. Do you have any information, Scott, about whose fence that is on the east side?
That I believe, like with 99.9% certainty is ours, only
Okay.
because it continues, the same fence continues along the eastern property line, and it continues and terminates right at my
That
driveway.
makes sense.
So I do believe.
And that one's right on the property
But
line.
again, that fence too was probably installed 30 or 40, 20, 30, 40, 50 years ago. I'm not 100% sure.
I got a question. As per the plan that you guys have currently in front of us, with changing your frontage to face, I guess that's Smith Street. Like you asked before, the side of the house then that's facing Parker, the existing, you would leave, like you said, you would leave the front door there, you'd leave the driveway there as well?
Correct.
Okay.
And then no
So-
changes to the roof line then, if that's, you were speaking about changing the roof line.
I would, to what we discussed before, I would prefer to just keep the house
As is.
100% as is. You know, notwithstanding maybe siding changes in the future, but the appearance of the house, you know, the elevation and the roof line, all that stuff. Keep it the way it is.
Does your address change regardless of whether or not you put a door there?
I don't know the answer to the question.
I'm just
My
curious.
experience has been the post office and the towns have different perspectives, but
This is a purely zoning thing.
Yeah.
This has nothing to do with the post office or where you put your mailbox or anything.
I mean,
It's
just that-
purely a zoning.
we've had this issue come up over and over, and the post office, you know, the federal law trumps the town law, whatever the federal government wants to do about what your address is, we can't really fight them too much on that.
I would
So
prefer.
if the post office wants the mailbox on the street, it's on the street, if it's on the house, it's on the house.
Yeah, I usually fight with those guys.
So I'm still a little bit unclear about that. Are we at a point where we're not gonna move the front door, or we still have to move the front door?
I think we were looking to the board to perhaps have an opinion or discussion on that point, because the applicant is flexible. He's proposed a plan that's before you to, I think we have to move the front door either way. It's just whether he would, you know, take off that front. If we don't move the front door, we would need variance relief in order to not have to move it. So that certainly would be welcomed by the applicant, but we're before this board right now on an application that we will comply with moving it, so we don't need relief for that. We will move it back 1.3 feet, so there will not be an additional setback variance. It's a one sole.
The applicant's preference is if you don't have to do it, then just leave it as it is.
That's right.
I'd rather do that, but it does bump another variance. I will tell you that in my reading of the notice, that's adequate because it's sort of a give and take as to what's happened during the course of this hearing. So I think you can grant that relief I think the notice is adequate for that purpose, because there is what I would characterize as catch-all, and such other relief as the board finds necessary as they explore this, so
So
that's
do we-
available to you, so we'll talk amongst ourselves.
Oh, okay, 'cause
Yeah, I would just say that that's probably the most confusing part of the testimony so far is your testimony was very clear that keeping the house intact is positive, and the owner has attested he wants to keep the house intact. Yet you're talking about what looks, and I'm looking at it on street view here as you're talking about it, and it, to me, it would really change the appearance of that corner if all of a sudden you're trying to direct foot traffic to that side, I'll call it the side of your house for now. Whereas it just sounds like you might need to tweak your language. And you'd actually, all the dominoes would kind of fall in line, you know what I mean? Like the house would stay, the appearance would stay. I think that would look good, you know, aesthetically from the street. The address is a completely separate item.
And now that we're hearing this from the planner and some comments from the board, we're on board to do that, and as Doug mentioned, our notice suggested that any additional variances that the board might suggest or professionals would be available to us tonight.
Can I
So-
can I just add one thing? I do not wanna modify the porch. The only thing was, I was looking at this, people like, they're not gonna approve 2 variances to keep this house. The house is not gonna, that's what they told me. That's what everybody said. I said, I wanna keep the house. So what I looked to do was to present the most correct form of the house so that it would stay. Even if it meant a minor modification instead of a demolishing of the structure. My personal preference is not that at all. I wanna see 65 Parker on the door and I want it to stay. That's it,
Right, so
if possible.
Can I ask you a question? And I may have missed this in your testimony. The new proposed lot, what would your new rear yard setback be?
everything on the new one's fully
It
compliant.
would comply, it would be a fully compliant rear yard setback of 30 feet.
So from the back of your house to the lot line would be 30 feet,
Yes.
but it would change the side yard setback. Would change.
Everything with the new lot is gonna be fully compliant, it's shown.
Sorry,
on this
maybe
plan
clarify
here.
your question. Are you talking about the new lot?
I know, I'm talking about the old lot.
The old lot,
Yeah.
yeah, okay,
Yeah,
sorry,
the lot that you're looking to.
to keep the house on.
Yeah.
Maybe for
Yes.
purposes of the record,
That-
refer to that as the corner lot, and the other lot that's going to be bigger.
The corner lot.
The corner lot,
So,
that's the one variance we're seeking, is because of the shift, it would change that to be.
it goes from, it's
So-
18.8 feet, right?
Correct,
And,
what's existing,
30 feet is what you're required.
right?
Is there on the north side of the house, that would now become the side yard setback?
Correct.
Yes,
And what would that be?
Should be 7.
The side yard setback actually is 7.7 feet, where 7 feet is required. So it would
So you
comply.
need-
You mean-
you
okay,
comply.
It would comply.
yeah, the only setback issue we have is the one in the rear that's a pre-existing.
Right. Which leaves you very little property. You know, on the
Oh,
side,
meaning-
you know, on that corner around your house, the eastern corner
understand.
and the northern corner.
Right,
It's pretty,
It-
pretty
it's-
shallow,
yet it's, because of the placement of the home, you're saying,
right?
right, but yet it is an oversized lot, it's 7,700
Right, you have a lot
or
of property in
7,
front of the house.
Yeah. right,
Yes.
that's a fair comment, understood.
I had a question about the streetscape. Could you talk about the existing streetscape on Smith? Because as I understand it, there are no other lots that are divided up in this way. As I driving down Smith, it's 2 and 2 and 2 houses.
I think our aerial shows. There, you have the house of worship here. You have this lot, which actually fronts on Parker directly across the street. Again, it's a narrower lot, it's more, the proposed lots are more in line with the size of this lot. Similarly, along Parker, these are long, narrow lots here, as you can see. There is one lot here that appears to be similar in size to this lot, although it has a much, much larger house on
Agreed.
it, okay? But the other lots in the area seem to be more in line with what we're proposing, rather than the existing lot.
Okay, I'm not sure if I agree with you on that. It looks like, in my reading going down Smith, it looks more like there's, a house or so in each one of those, blocks.
When we looked at it, there were some narrower houses down there as well.
In the future. Yeah, that's what I'm afraid, yeah, that's what I'm thinking.
Anything else from the board? The next step would be to open up to public, I believe. Or, because we've gotten the testimony intermixed, I don't think there's any further presentation from our planner, any further presentation, Richard. So we've covered that. I think now we're just open public.
Yeah, I mean, before we even get there, I mean, I think we should discuss a little bit more. If it's worth changing the entire view and streetscape of the existing houses, if he wants to stay completely there. Okay, fair enough. Any public comment?
Step forward, please state your name, spelling your last name, purpose of the record.
Brad Moore,
You solemnly,
on Parker.
Mr. Moore, would you solemnly swear the testimony you give before the board will be the truth, the whole truth, nothing but the truth?
Yes,
And the spelling of your last name is Moore.
correct,
First name is Brad.
yes.
Thank you, sir.
I think this proposed plan, the front yard becomes somebody's back, like that's where you're gonna barbecue. What I don't understand is why we need to have like a giant lot on Smith when you only need 50 feet. And so, like everything, then the house on Parker retains everything. And then you're probably saving some of these trees, and then, you know, the house on Parker is really just a shorter backyard. But if otherwise, I think we're making accommodations to make a goofy house and, with a weird lot, and, it just seems a little weird for the neighborhood, but I don't understand why we want to 50 feet on Smith. It just makes more sense.
Anyone else want to have a comment? Step forward, please. State your name. Please spell your last name for the record.
Josh Halbert,
Thank you.
ALPERN. It's clarification. 2 trees came down already? Is that accurate?
When your neighbor had that problem we talked about when he came home with the trees, there were 2 trees that were along the neighbor's property line, is that what you're?
I believe that's what Rich said. I thought there was only one, that picture that, but I believe that there is 2, a small one. Yes. I think that's
So the 2 trees that came down, there's another tree that you're suggesting would come down on the new property. So that's 3 trees as it relates to how we calculate clear cutting of the lot. Is that accurate? Rich?
Possibly, yeah, we haven't gotten a formal submission on what they're.
Definitely looking to plant a new tree to compensate for the one that would be taken down if that's the case.
So where I think I'm going with this is, trees have obviously been a very, very, sensitive issue in the borough area, is the way that I would put it. And, I just want to make sure that we're not bypassing the 2 trees when we just talk about the 1 tree out there. I don't think 1 tree is going to suffice. And I think I'm just getting ahead of that so that the discussion is had now, and it's understood that when it comes before the council, if there is some sort of relief that's needed at that time, that the council and the governing body is most likely going to impose the entire tree ordinance on the applicant. Thank you.
So he's referring to if it's considered clear cutting or whatever number of trees were removed, there's a possibility that it has to come before the governing body for an appeal. Because most likely tree permit that gets submitted after the fact will be denied. That relates to the work that's been done.
Because of what happened with the,
As it relates to the prior work that was done without a permit, and then whatever the applicant's proposing.
right,
We haven't gotten
But-
anything formally submitted.
Understood.
On the plan that
but
shows,
that's not before this board tonight.
well, we're just making you aware of that it's,
Something the applicant has to deal
additional-
with. If something happened in the past, you know, and we've had things happen before us where somebody took somebody else's fence down. You're gonna have to make it right, one way or the other,
Right.
and that's what the ordinance is for.
the one thing too, and one of the board members mentioned tonight, we keep hearing the word, I believe, I believe. I think the owner of the property should know what happened.
Mhm.
And the purpose of being here tonight is put that on the record. That's why I brought it up in my report. That's why we walk the property. We look at everything as it relates to the property for subdivision. So, I think there's some clarification that needs to be done there and some additional work that needs to be, taken care of. So,
Brett, I think the testimony was that it was, very thick brush over there and it's a part of clearing the brush. There were trees and doesn't recall exactly what that was.
I think a lot of people go through, I've heard people in town jump through hoops in front of the council to make sure that they're doing the right thing. I think the issue is the right thing wasn't done here.
Mhm.
That's what I'm hung up on because it is a process to get trees removed correctly. It didn't seem like it was done this way, so
Right,
it's a problem.
and I don't think it was the traditional, like, I'm going to cut my tree down kind of thing and let's go forward. I think it happened in connection with clearing some brush was the testimony with the neighbor.
Sure.
And then learned about, after the fact and it's like, oh gosh, I guess you gotta do this. People make mistakes. My client obviously didn't stop what was happening and hit pause and go back and get it done the right way. And was kind of initiated by the neighbor, so. And I understand your concern, but that's what the testimony that was presented today.
Do we know real quick, what the condition of those two trees were that were taken down? I mean, I keep hearing about brush overwhelming the area on that side. What? An expert opinion of what the condition of those trees were.
So I have two small children, they're 3 and 5, and we would play in the backyard here, and there was so much poison ivy back here that the one landscaper didn't even want to touch it. And it was wrapped up around the tree. I believe the tree was dead, what by the time it was exposed, and you could actually see it once it was cut back. So and then this entire swath, it was 20
And for
feet
purposes of the record, we're
Yes.
talking about the aerial view up near the yellow. line.
Northwest corner.
the northwest corner, but continuing along the north property line toward the east corner. Almost the entire thing, with the exception of the northeast corner, there's a tree there, I believe it's a cherry, I'm not a tree expert, but I believe it's like a cherry tree or one of those type of trees. Which was not touched. All the rest of this was, I was concerned for my kids going back there and whatnot. I mean, it was a total mess. It needed to be looked at anyway. And the neighbor putting the fence in kind of just like prompted that. And again, I apologize for,
Well, no, just to your best recollection to the question that was asked, you've mentioned a cherry tree, you've mentioned some brush. How many other trees do you believe were removed?
I believe that there was only, until I believe in Rich's report that you said a second one, I thought there was only one stump that I believe was the one that was totally wrapped in ivy, and I just.
Okay.
And it was,
And to your knowledge, they're both ill trees, right?
correct, that's correct. The whole that whole area was like a do not go there, it's scary for the kids, that type of thing.
It's pretty direct, no picture.
That's the one I remember. The other one,
Okay, if you want to highlight what you're referring to.
So we're looking at the attachment to the engineer's letter dated March 14th. That was marked, I think is P1.
Yes, PB1.
PB1, the very end of it, there are two photographs. And at the bottom photograph, there's a stump.
and that's the one that I recognized that was wrapped, that appeared to be decaying and was wrapped from from top to bottom in ivy. And I didn't think it was.
I think you can look at the stuff and probably have someone determine.
Well,
I mean-
he's gonna have to grapple with that with the tree permit. That'll be, to the extent that he needs.
You don't have any
permits.
distinct recollection of any other trees besides this one?
No.
Okay.
I think the engineer made that a condition. I think the applicant said they're going to address that. I'll address it. I do have some omitted questions that I wanted to ask by way of proofs, if I could. You understand that, and if you you don't, or if there's a disagreement, that separate utilities serving each of the properties has to be placed, and the utility plan will have to be reviewed by our engineer.
Yes,
Okay. I understand that you're going to comply with the New Jersey Recordation Act, but either way, by way of map or deed.
yes,
Okay. That in this instance, I guess the extension of certain facilities are not going to be at the expense of the municipality, but at the expense of your client. Such as
Yes.
water lines.
Yes.
Okay. You did mention that you're going to have to do some, I believe your professional mentioned there's going to have to be some grading on the site.
we'll be
Correct?
submitting a grading plan in
Grading
accordance
plan,
with the
okay.
engineer's
Okay.
request.
One of the burdens that the applicant has is to demonstrate that, that there's not gonna be any adverse effect on drainage. We didn't hear anybody give an opinion with regard to drainage at the site and or the drainage problems. Is there gonna be, I do know that there was one board member mentioned, is there an opinion with regard to whether or not the changes that you're proposing will adversely affect drainage inside?
We don't show any on our plans, so I'll say no.
Okay.
We're also stipulating that we will provide a grading plan to the borough engineer.
Do you have an opinion as to whether or not the development, this site will adversely affect any further development in and about the area? I'm assuming the answer is no, because it's fully.
No, the answer is no.
Okay. Have any portion of these lands that are involved been involved in a minor subdivision within the past 3 years? I'm seeing
No.
shaking your head, I want
No.
somebody to say no, love.
No.
Okay, thank you.
I can't testify.
All right. Thank you, Mr. Chairman.
Any other public comment? No?
Close public.
Yeah, close vote.
Discussions by members of the board. I do want to highlight some of the relief that's necessary in this instance. You've heard. I'll leave you the items I think you've already begun to discuss. We have that discussion. And we'll come back out and we'll frame a resolution one way or the other. But I do want to, the applicant did discuss C1 variance. That's a hardship variance. I think that's generally applicable to the existing structure that they want to maintain at the site. They do get a benefit to demonstrate that that's hardship. Now, the self-created hardship, when you're putting down the lot line down the center, to the extent that they have presented testimony that that new side yard, if you, may I ask to just put this up,
Sure.
that new side yard that you have now between the two lots, based upon the testimony that's presented, obviously you don't have what's going to be built there, but they at least have testified that with this variance relief, and I'm assuming they would agree that they're not going to need any further variance relief, that they can build something that's conforming, and that the both side yards there are going to be conforming to your zone requirements. The other issue that you have is because of the placement of the existing house and because of now the new side yard lot line, that discussion of flipping as to where the rear yard is makes that new rear yard non-conforming. So that's something you're going to have to grapple as to whether or not that satisfies the hardship criteria. The other criteria that was discussed, and I in fairness to the board, I think we need to amplify what that talks about, is what's known as the flexible C or C2 variance. In that instance, with regard to a C2 variance, hardship doesn't have anything to do with hardship. And because it's not really based upon the individual property owner's hardship or the conditions that exist at the site. In a sense, it's what you're looking at, and I'm going to read some of the words from the court, is does this new plan have a benefit to the overall master plan and our development regulations? You heard some testimony about character of the neighborhood. You heard that it's going to be residential to residential. Our New Jersey Supreme Court in Kaufman versus Planning Board for Warren Township, speaking on the general concept of C2 variance, stated that by definition, no C2 variance should be granted when merely the purposes of the owner will be advanced. The grant of approval must actually benefit the community in that it represents a better zoning alternative for the property. The focus of the C2 case then will not be on the characteristics of the land that, in light of the current zoning requirements, create a hardship on the owner, warranting a relaxation of standards, but on the characteristics of the land that present an opportunity for improved zoning and planning that will benefit the community. So in this instance, the applicant is presenting to you an oversized lot and saying that by dividing up the lot and granting the variances that I've asked for, we'll still keep a residential house that's in existence, but we will also be able to create another conforming residential lot in the area. I leave it to you to decide whether or not how it's being designed is consistent, and I think you can look to the area and say, okay, how are other properties not only on this block, but facing the other block, but they'll be facing in and about the area. And I believe one person already identified that, and we have some discussion on that. Again, as to the other criteria, every variance is, to a certain extent, a detriment to the zone plan and zoning ordinance, but the language that you're bound by is a substantial detriment. Does represent a substantial detriment, because every little tweak that you have for a variance, it's not conforming, that's why you're here. You have to say whether or not it's a substantial detriment, and based upon what the applicant is willing or ready to do, concessions, I look at those as little chips, you know. If you, having nothing to do with this application, but let's say you couldn't provide a buffer between two houses because you were non-conforming as to a side yard lot line. What was the applicant willing to do? Maybe it's a fence, maybe it's green arborvitae, those kinds of things to ameliorate the negative impact. The applicant has gone through the engineer's report and the planner's report. And I believe, I don't recall anything that they said that they're not going to comply with those things. It's going to be conforming. I think you need to discuss whether or not what they're proposing is a substantial detriment, because it's a conforming use, pretty much conforming lots, except for where, you know, ideally, if you could move that house and just shift it one way or the other, you might be able to do that. You've heard the applicant's preference for trying to keep that there as they can, but because of the nature of the subdivision, they have to flip the rear yard, and that's non-conforming. And they didn't really discuss carving off anything off the backside. I don't know that that's a practical reality. So I leave that for you folks to discuss about that. I leave that for you to discuss what your thoughts are with regard to, you know, the additional variance that you would be granting if the applicant doesn't do anything to that corner lot porch. I'll refer to it that way. So as they say on SNL, talk amongst yourselves. Share your thoughts. This is what you.
Is it too late to ask the applicant a question?
It's not too late to ask, you know, no, I don't think so.
Mr. Moore brought up, a point that if you kept the new lot at a maximum of 50 feet, which is required by zoning, that would make your new side yard setback wider, correct? The northern.
It would make the corner lot side yard.
Yes,
setback
yes.
larger. Yeah.
Would that save the tree?
Then the tree would straddle the lot line, I believe.
It would.
Yeah, that would make it very close to it.
I believe it's right at the, I know that the root structure would definitely straddle out. And to your point, I definitely looked at where to draw the line per se. I thought that giving the most evenly spacing, the most even spacing that you could to the lots was more important. Because the corner lots, by nature of being corner lots, have to be slightly larger. Their mandatory minimum is 7,000 square feet versus the interior is 5,000. So what I was trying to do was just kind of make it as close to even as possible, with still keep creating the conformity. It would have been 65 and 70 is what I was looking at, but with the position of the mechanicals on the back of the house, the air conditioner on the back of the house, that extra foot was needed to create And that's how we came up with 71. It wasn't an arbitrary number. I did look at that. And I just tried to keep it as even as possible.
Can I ask a follow-up question on that? With the proposed, this is more of a planning thing, with the proposed width of 64, our ordinance has a provision about an oversized lot. Does that allow them to increase the floor area for the home?
For our 7.5.
So it's in table C, I don't have it in front of me. I don't know if their planner knows that, so. If you have an oversized lot.
Table C or air attachment 3?
In our, in the zoning ordinance, I think it's references table C.
Attachment to the overall.
That would increase above the cap, the 22
That
cap.
would increase, there's a potential that would increase above the cap for an R5 zone, which is currently 2,200 square feet.
I don't know about that, because that could help us too, because that one's oversized too.
Oh, right. Yeah, 5 is the definition for it, but it's 80.
I know that the side yard, there's a sliding for every. But I think there's a provision in there regarding. For area. Which would mean the potential of a larger home.
Rick, regardless, of wanting to make the door face Smith Street, if that was the route they decided to go, we're leaving it existing as is. The property, since it's being subdivided, meaning the shortest side is that area that he was talking about putting a door in. That's gonna be the front yard no matter what we decide to do here, right? By code now, by zoning, by. Even though the front's really gonna be facing another street is,
Well, he's going to have by
By
definition.
definition.
Yeah,
the
that's gonna be
rear
the
yard-
designated front yard. He's got 2 front yards.
right, designated as the shorter,
Correct.
so.
Like, definition, whether you show it a 50-foot wide lot or a 64-foot lot for the interior. The corner lot, the rear yard will become what is now the side yard as we see it today.
Right, back here.
So
So we have a giant side, a conforming side, a non-conforming rear.
In fact, you've got a greater depth lot on Parker Avenue than you do on Smith Street.
What defines the names is the orientation.
And that's our function of our ordinance, that the shorter side is your.
Right, your front,
Yeah,
front.
but in terms of granting the relief, we're in a sense saying, I don't know that we're changing that that's anything there, other than he wants to maintain his front entrance. Not do that. It's almost,
Yeah,
Yes, but technically, the way the house is currently sits on the lot and is used. The back door is really in the rear of the house. You know, off behind Parker. Which by definition.
I'm
becomes,
assuming,
You know,
I'm assuming, and I'm not asking that, but I'm assuming if you grant him the relief not to have to do any modifications to the house. He's gonna enter what he considers his front door and his driveway from
for
Parker.
property, like existing.
Like you
I
said,
don't think anybody really.
I don't think everybody's gonna know.
Same
You'll
old-
know.
Same old, same old.
Yeah,
You know, you'll have that idea, but, and for purposes of what we're doing, we're gonna cross T's and dot I's to make sure that if you grant that relief, we're not saying you have to, but if you grant that relief, you know, he has done what he has carried through on his paperwork and done everything he was supposed to do. Okay?
Right, so the question now is in regards to what this far.
Now it's,
Did you guys
what was
find
the
something?
conclusion based upon the question that was offered by the engineer?
Can you ask your question?
to my,
Please repeat the question, John.
Yeah.
Huh.
And then the left side.
my question was. There was discussion about
Size of the lots.
size of the lot. Based on the current proposal, does the applicant have the administrative right to build a larger home than permitted in the R5 zone? since there is a provision, I believe, in our code that allows them to go up to the next zone. And if so, would that lot meet that requirement?
So the answer is no, they do not have the right because it only applies to existing lots.
It only applies to.
And that's note 10. Oh, it's 11. It's 11. If an existing residential lot contains lot area, lot width, and lot depth compliant with the zone above it on the chart, it may be constructed in compliance with those standards.
So since this is not an existing lot, it does not fall within the 11.
Right, would not apply.
And you would, unless there's a concern or objection, you could address
That's
that.
a matter of timing, you know.
You could
Right.
add it to the resolution.
We can
I
add that
just
to the
want to bring
resolution.
to the board's attention.
Sure.
Because
What
that
is-
potential.
That was a good mental exercise.
If it was considered, what is the
Might have been a
What is the
change.
square footage then that you're allowed to have?
I'm sorry?
I said if it was allowed, like Rich was saying, or if you can build bigger, what is the limit or square footage then of that?
If that provision did apply.
Right,
If that did apply, the next zone above would be the R 7.5, which requires 75. It also doesn't comply with the lot.
Doesn't apply with the lot size.
So even if it were, it's existing, it doesn't comply.
That's completely conforming to fit within that.
Right, it'd have to comply with the frontage and the setback and the lot area.
Got it, all right. That's why I'm.
But if it did, it would be a 3,000 square foot house.
So talk amongst yourselves.
I mean, I feel pretty strongly that the front, everything stays as is, like, I think it's gonna look silly to put a front door on the side with the front door existing in the driveway, like, I feel pretty strongly that it stays as is.
I just have questions again about the streetscape on Smith. This really does make Smith more dense. You're adding a whole nother house, whereas in the existing streetscape on Smith, it's deeper yards, a garage, parking lot of the place of worship. So it does change it a bit. And I've already mentioned that really concerned about.
How would that be, how would that be? any different?
That would be with the master plan.
If they built two new conforming.
Right, right.
I think that's where you're trying to grapple, because I think that's what the applicant has presented to you. It said, look, by right, if I don't get this relief, here is by right what I'm allowed to
Right,
do.
right, right.
Unless there's a change in your zoning. So it's a valid point. I think you have to take a look at, and maybe that aerial is helpful in that instance. It's clear that there's a gap. That's fine. But to your point, yeah.
I would say to add on, that aerial is a very small window of this neighborhood. So
Yes.
if you scroll out just a little bit, I would say, we talked about it already, so 66 Parker is a similar size lot with a single home on it. 53 Jackson at the next block, so Jackson and Smith is a similar size lot. The adjacent corner of Smith and Jackson looks to be the future of what this could be, which is two homes on that same lot, 173 Smith and 61 Jackson. So you could argue both ways. It's clearly taking away what were intended to be larger corner lots and making it smaller lots. But that's permissible.
Other thoughts?
I mean, I see no need, in my opinion, to rip a foot off your porch to put a door on it, especially when you're trying to keep the house and not knock it down like everybody else does around here and build some giant thing. Again, in my opinion, now I understand it also created an issue in the back now because you're at 18.8 instead of 30. You're again getting to this division line that you decided to draw down the middle of, like you said, trying to keep kind of even Steven down the middle, right? That other lot would be considered an interior lot, and it can be 5,000 square feet,
Correct.
and it's currently at.
6,000 to 6,600.
So is that extra 1,600 square feet of that line.
I think we need a minimum of 50.
You need a minimum of,
Frontage.
oh, frontage, yeah.
Yeah, so even though it's deeper, so the smallest it could be was 50 by 104. Which is a little bit larger than fine, it can't be smaller than.
And I just, my personal opinion, kind of like we're all sharing is, if you're looking for relief and trying to do, what's best for the neighborhood, that's a reasonable request to consider. Is giving yourself a little bit of a wider backyard and a little bit of buffer with your potential new neighbor. To keep that kind of green space around the house that is quite significant now, at least trying to give yourself a little bit more barrier, green barrier on that new side yard.
Make the interior lot even smaller than it is.
The recommendation on the floor was to make it 50, which is the minimum. I'm saying I think that is something that the owner should really consider, because it will, rather than try to lop off a porch, which has a foundation and doesn't sound like that's really practical. You're seeking certain reliefs, giving up and maintaining that buffer of green zone on that side yard, which is effectively gonna be his actual backyard. That it is today. I just think that's a reasonable thing to consider.
Yeah. So I'll say something because. Sure. It's just. It can't be no streetscape, no additions. This
What-
is not the same picture.
What does, I mean, I know they're discussing right now, but between us, what does moving the property line? Necessarily.
It maintains, I guess, to what Sean was saying, it keeps a little bit more of the streetscape in that corner lot. She had the corner lot being a little bit larger, which is how it is usually in corner lots. Whereas now it seems like it's a little compressed, particularly in the back.
Yeah, well, I think it's got the potential for.
And it saved the trip.
Yeah, well, I don't know, does 14 feet save that tree?
It will definitely push the side setback of the potential new building. It will push it away from the tree as it's strong on this.
It'll push it away.
This is me chiming in as a planner, so I didn't mean to intrude in the discussion, but I think there's a validity to the point that homes need, the space on the frontage from now, it's got two frontages, that's public space, basically, or semi-public space. There's no private space once you draw that lot line that close to the house. Really is no rear yard anymore, to your point. And to the extent that that can be enlarged, so you have some place in the rear of that house, I think that's a benefit to not only the home, but also the neighbors. So that, in the future, somebody's not trying to put a fence up, in a front yard to have some privacy or something like that. So I think that there's some validity to that. I do think that I don't have any hope that that tree in the middle is ever gonna be saved, because the root zone for that oak tree is all the way across the yard. And once you start biting into that, it's gonna fall, even if you were able to save it for a few years, it would be a dead tree walking.
You've got roots at least at the drip line.
Yeah.
Yeah.
The roots are-
Well, technically, to build on that house, right, if your property line moves 14 feet to make that a 50-foot lot. And then your setback of your build, it has to be what, that'd be 7 feet off the side of that property line. So you got 21 feet that you're moving and saving. So I mean, it's a little more significant than just a 14, I'm thinking, where they can build.
Where are the mechanicals in the existing house? Are they?
I'm sorry, was there a question? Yeah.
She asked.
Where are the mechanicals for the existing residential structure on what's going to be the corner lot?
The survey shows
Is there an air conditioning unit outside?
yes, A5, the survey in the, if you will, the current house, it's in the rear up against the house.
There's also a generator, I believe.
Yeah, there's a generator. So by adding up like another 14 feet to the back of the house, you give yourself a little more buffer with those mechanicals for the house next door, the new house.
I also, I don't mean to harp on this, but this, I am on the environmental committee and the planning board, so the tree issue is just really sticking. I'm looking at a Google image of the property. I don't know when this picture was taken, but it's, you can see it's lush, and if you go back to your last image, that, where did this all go? You know, this is a big problem. This is clear cutting to create space for a piece of property. I'm looking at my phone from, I'm not sure when, to be honest, and this image, they don't even look like the same property.
Do you
This
have,
was also taken in the winter, all the trees around here are dead. In the summertime, it might have looked different also.
This is a ton of canopy. These look like massive trees. I mean, I understand, I have young kids too. I don't want anybody planting poison ivy, but they don't even look like the same properties. So I think that it needs to be said that you have to prioritize replanting. It's not going to equate to what has been pulled down, but that definitely needs to be a priority for both properties going forward. I think that you can't, you know, there was talk of just, we'll consider it. It has to be a priority for sure, especially if we were looking at something like this at one point.
They want time to talk about.
You guys want to have some talk? We got some other business we can do. You want to take some time to discuss? We've got some other business we can take care of.
still two trees in the front.
Yeah.
But I think it's more, we're trying to understand, because it seems like a few people mentioned moving the lot line, make it more, maybe more palatable to keep the existing home. So, one thought was moved all the way back to 50. Maybe there's some compromise in between. The thought was that you didn't want to just kind of squeeze the smallest interior lot possible there. And since this is a really very oversized lot, it's 14,000 and only 12,000 is required for a corner in an interior lot. Maybe there's some space in between that would make more sense for both properties going forward. And if it isn't, you know, we just like to know, just kind of throwing that out
I
there.
agree with you. But in this case, it's where the house sits in that northeast corner that really makes it tight. That if we could maximize the amount of space between the existing house and the lot line, I would be more amenable to that.
Okay,
I mean, just think about 7 feet is like me to Anna,
right.
just like to put it into perspective,
Well,
it's just,
it could be moved, the maximum would be 14 feet.
right, which would be like
Yeah,
Right,
outside the wall.
And then another 7 into the build. The
but
rest would be
Yes,
their grass.
yeah.
Which is-
Right.
That's 21 feet. It's a
but
lot further.
the board's consensus is to move it the maximum distance rather than somewhere in between.
maximum.
Because we would also make the interior lot the minimum size it could be.
Right, yeah, and to the point, you said, once you move that lot, now you need your side yard. So you're moving your building envelope closer, well, not, you're really not, you're probably gonna try to maintain that one side.
Well, it's like-
Or Jim said it's 7 feet.
The testimony from earlier is, I mean, if you look at Parker Avenue, 50 feet is not out of the, I mean, it's.
Well, let me just say this.
7.
This is an as-of-right subdivision. If we take down this house, this can be approved, this has to be approved as a matter of law. Am I correct? As of right, if this house comes down, this is an as-of-right subdivision.
Yeah,
So there really is no way it could be denied per se, divided into 2 lots.
I will
Right.
tell you that the term as of right is no longer recognized.
how about compliant?
Compliant, we'll do compliant then. Compliant, that's fine. But it's a compliant subdivision. We could move this lot line. It probably won't protect this tree. I would argue it wouldn't.
Right.
I think your planners agree that this tree is not
It
protected.
would give you a bigger back.
We've already agreed to protect these other 2 trees on the property, correct?
Yeah.
So I mean, those are protected. I can't speak to what happened in the back here. I can only say that we know that there may be 2 trees back there that were cut down. And apparently they were dead. That's the testimony we're hearing tonight. And there was some brush back here, which may, you know, I can't really tell from the photograph exactly what it is. And looking at it now, it doesn't really help. So my point is that they are compliant lots. We could make this lot a little bigger, but it will make this lot it'll make this lot smaller, and you'll have a smaller house in the lot. So it'll be more, it'll be like these houses here.
It'll be the same, it's gonna be 2,200 square feet, it's just gonna be a smaller
It's
lot.
gonna be the same size house
It's gonna be-
essentially, because you can't go over the 22.
It's just gonna be kind of crammed in, and the applicant's thought was like, let's make it a little bit more balanced, let's comply with the setbacks on the side yard. But if the board feels strongly, we can adjust that line. We just didn't think if it was adjusted, it would go all the way to 50 and, so it'd be, the total distance over here is what, 135?
135,
So.
71 to 64.
Yeah, so you'd be going, 80, 85 and 50. Which is a really big lot and tiny little lot, so the 61 and 70, or 64 and 71 seem more balanced.
I was just trying to balance the view to both perspectives. I understand what you're saying completely, and I was just trying to balance both perspectives of, hey, if we put a new house on that lot, how's that gonna look? 50 is the minimum, but wherever possible, you don't wanna have the minimum, you wanna have a little bit more than the minimum.
Right now, they're both oversized.
So I tried to make them as equivalent as possible as far as dimension is concerned. So that they,
And I would say when you're on Parker Avenue, that totally makes sense. That line of thinking of making them look equal totally makes sense, but you're not, you're on a corner.
Yeah.
And your house is offset on the corner. So I think that's the only thing we're observing from what you've shared about not wanting to adjust, you don't want to tear down your house. As someone who's been in your shoes before and not going down my house, I love hearing that. That's great. I just think that's the feedback is your intention was right, but I think it's the context of being on the corner.
So if we were to modify this application to propose a lot line change, I don't think we need, we don't want to come back, but we'd like to, as long as the attorney feels like that's okay to incorporate just a simple lot line change from what's been proposed.
No,
to
I mean,
comply
you're proposing.
What the board's
subdivided.
asking.
We're not,
And in that same breath, we would then be creating a much larger backyard if we go with the not touch the house
I would
at
want
all.
the applicant to feel comfortable, because, usually what's going to, well, some of us want the board to feel comfortable too. Because usually one of our conditions is, as I've alluded to, is that, the applicant can build without the need for having to come back with further variance relief. So, and if you're going to do that lot line, and you're going to do because we aren't here for site planning. We're here, what they're going to do is they're going to give you a building envelope and they're going to show that they can, I don't know if anybody has touched on it, but one of the applicants, one of the applications was the lot shape diameter. Has that been addressed at all?
Well, talking to my client, he suggested that if we are gonna move it, he would ask that the smaller lot be 56. Because he's built other homes recently. And
I built that one home.
he built one home,
for-
another home, and
Yes.
And based on the layout he's trying to squeeze into a small lot, and he said 56 seemed reasonable. So 56 would then take it from 64 down to 56, that would be an 8-foot increase. So it would be 79 and 56. So you'd still instead of having a 7-foot setback there, you'd have 7.7, you'd have 15.7.
It's simple.
Is-
It's not just.
Would that be maybe a fair compromise, just having the extra 6 feet on that smaller lot?
So what they're proposing is that along Smith, that proposed lot 3.01 would then be 79, and proposed lot, the interior lot 31.02 would be 56.
That's right.
Frontage along Smith Street. That would obviously increase the side yard on lot 3.01 at the expense of lot 31.02. And
That's 58.24.
it would change some of your numbers with regard to
And their FAR gets a little better,
FAR. Their FAR probably gets a little bit better,
but it's
Either way.
already below the cap.
and it's already below.
And there are no variances associated with that, with respect to that side yard. The variance still remains in the rear yard, but that's.
Yeah, you're still, you're
It
still,
doesn't exacerbate anything we've already proposed.
I would want to have new numbers as to what the cap is then.
Cap on,
Cap on which, on the new lot?
It wouldn't change.
It wouldn't change.
no,
And
The
the cap,
2200's on both lots, it wouldn't make a
Right.
difference.
Yeah. and the ratio goes down on the larger lot,
Exactly.
and it's to be determined on the new one.
where are you folks?
Well, I can tell you, I have no problem with you leaving the house exactly the way it is. I think it would be awkward to try and build, either take, putting a half off the side or adding a door, or changing the elevation. I don't think that's necessary. But I really feel if you move it to the 50-yard line, and I have no problem with what now becomes your rear yard setback variance for that. But I would like to see the maximum amount of space you could give to the corner house, new existing side lot.
So their proposal to 56 is not,
And
is
that's
still
not
6
appealing
feet.
to me, because I'm willing to give on the other two issues. But I feel that, you're building a new house anyway, you're not accommodating something that already exists. So you can build a house to the zoning standards for a 50-yard lot, but that's my opinion.
How do other people feel?
And I think to speak to saving the tree, the further you move everything to the north, the better chance you have
Once you get on
of.
Well, I would ask our professionals, but I don't know that you're saving that tree.
Right.
Either way, I don't know that you're saving the
That's for
other.
another group to
Yes.
decide,
And I
but
think,
at least we're making an effort to.
I'm not disagreeing, but I don't want anybody to be misled. I
Right.
don't know if you're saving the oak either way. You're probably doing better
Is there
for the sycamore.
other lots on Smith Street where their frontage is facing Smith Street like we're proposing here?
There's only one that I'm aware of.
One, and what size lot is that? Just out of curiosity.
I know. It's, so 173 Smith.
So the record is clear. This is Mr. Moore speaking.
Yeah, it's
It was sworn
according to
before.
the tax card, it's 52 by 135.
52, so.
That's the
Can't
only.
push it like
other
that,
house.
that's being 50.
No, that's what I was trying to. Really?
56.
Yeah. Right.
Where are people with regard to either 50 or 56?
Well, if we say, no, there has to be 50, they say, nah, I just knock the house down and put a line down the middle and do what they want, right? By law.
Yeah.
Right? So that's something else we need to consider,
Yeah,
right?
to me, that would be
That's-
addressing.
Well, then the issue of the side yard goes away anyway.
Right, so then there wouldn't be, in fact, they wouldn't even need to come for any variances from the
No.
planning board then.
I'm just
As
saying,
long as they
no,
build it to
that-
conform,
we're,
yeah.
we're worried about a couple of trees that came down, whether they were old and rotten or not old or rotten. But, if we say, hey, you have to move this to 50, and they say no, they'll just knock the house down and do whatever they want to do and build two houses.
Right.
So if we're concerned with the way it looks now and we appreciate that he's keeping the house and not changing anything, then maybe there should be more give there on them splitting these two lots that works out for them as well. Because again, in the end, if they want, they could just say, hey, we'll put it right down the middle where we want. I'll knock the house down, I'll build two new houses. You have two new houses there.
But they don't have to.
No, they don't, they don't have to.
Right, they also might agree to the 50, yeah.
You're not forcing them, but I'm just saying that option is there. So based on what we decide here, they can say, all right, thanks, but no thanks, we're gonna knock them down. And
There's a house, that's being built on Ridge Road, across from the high school. Have you seen it? That
Yeah,
new
they
house?
switched
The corridor between the back of the new house and the existing house that sits on Ridge Road. It is so narrow. I don't even know how anybody could walk through that space. And that's what I'm afraid of is going to happen here. So I'd like to see as much room as I can between the two structures.
So the property line off the back of the house was, as these guys propose, is gonna change to 15 feet. And then if they have a 12-yard setback, you're talking about 27 feet between the houses,
Mhm.
right?
Yeah,
Doing that.
well, I think
Right, the other one says
Yeah.
12-yard setback.
it
right,
does
12
state
setback.
12. Is there a reason?
Because it has
which
to
one?
stay 12.
Is there a reason this is
It
12?
combined.
Yeah,
is
it's
16.
combined.
There's
Oh, I
on the
see.
side.
Yeah, it's 7, just have.
Seven.
Seven.
So
And then 16.
it would only have to be, it would only have to be, 7, I think.
Okay,
If we shifted it, and then we'd be proposing to add another 8 feet on top of that. Which was the last proposal we had with the 56, which I know one board member was not in favor.
right.
But, we thought that was a reasonable compromise, and you're still having a pretty good distance between those two houses. And you're not just making this new structure, or the new lot as small as it could possibly be.
Right, so
How did you sell it 56 and not say 55 and even number?
Applicant, do you have any?
My wife and I were forced to, we had to squeeze a house onto a 56-foot lot, around the block. That's where we're moving to, right, in the process of doing that now. I just know that the detached garage, which is probably gonna be part of the plan when you're factoring in that, and you're factoring in the setback for the garage versus the lot line versus the house and all the different things that need to come into play. It's better to have more than the minimum. I mean, again, I'm not stuck to what we presented here. I just really tried to make the lots even.
And that's because of the frontage that you have for the house, but then the driveway that you're gonna need about 10 feet on the side to go back to a detached.
Yeah, and I believe that a detached is gonna be, what happens here. So to make, again, it's from the perspective of both lots, both from the corner lot and from the interior lot. When you're thinking about the interior lot perspective, we're really gonna be marginalizing both the interior lot perspective, and in my view, that adds to density as far as density going forward, going north, let's say, on the area. Because if you squeeze this here, then everything you're talking about here is either 50 or 50, either 52 each, right? Because that's 104, so 52 each. By making that, you're pushing everything that way, making that area denser at the expense of that. I didn't want to get held up with regard to that. I was just really trying to balance both sides of the equation and look at both perspectives and not one at the expense of the other. That's
So
really
it wasn't completely arbitrary, you just went through this and it's just realizing it's really hard to squeeze things into 50 feet. And it seems a
Did
bit
you
of
say you were moving?
he's moving in town around the corner.
Yeah, around the block. There's a long story there that.
Do you not live in this property?
We're in the process of moving right now.
They do live there, but he's building a new home around the corner.
We're moving around the block. The story here with my builder has basically ruined my life, and that's, I don't wanna bore you guys.
I would caution you from
Yeah.
making public.
Yeah, this is
Yeah.
a record.
Right.
The council's about ready to do.
And I wanted to avoid that at all costs, so
Okay.
I don't want.
They just asked a question.
Yeah,
This was your home.
sorry, yes.
This was your home,
Yes.
and you are moving,
Yeah.
you're moving in town.
Yeah.
He's the owner of the property.
He's the owner of the property, he's living in this home, he's also building another home where he's going to be moving to, which is down the street. He wants to save this house, not for himself, but to save the house.
I
Just for
think
the
that
house
should
to
have been
save.
made a lot clearer at the beginning. I still stand by my 50 yards. I'm sorry.
50 yards.
50
50 yards.
Yeah, 50 yards. My favorite yard football.
I knew what you meant.
50-yard line.
There was testimony about, how there was this house that
Yes.
he was
But I
building.
thought the whole thing fell through. That's
Yeah.
what I-
Oh, no, it
Second
didn't fall
one.
through, it just got delayed, and he had to get this house in the meantime.
But the way you were talking was like, I love this house. I want to spend the rest of my life in this house.
He just wants to walk by it and know it's still there. It
Okay.
still has.
It's in every sense of the word, it saved the day for me. If not for that, I don't know where I would be. I'd be renting some, anyway, I'd be throwing money down the drain. So. Not living in Barry, that's for sure.
So what are our options?
What are your options? I'm gonna frame a resolution at the proposal of the applicant, because it's ultimately the applicant's application. The applicant has put before you modification of 79 and 56. Everybody understand what I'm referring to?
Yes.
Yeah.
Okay, and I'm a frame a resolution, I always frame it in the positive, that's not to influence you one way or the other. For the relief requested for subdivision relief, it's not site relief, but for subdivision relief, modification to the lot line between the two properties so that the frontage along Smith for the corner lot will be 79 feet. And the frontage for lot 31.02, the interior lot, will be 56. We've heard the testimony of the applicant in this instance, largely that they're going to comply with all the requests and requirements and suggestions made by the engineer and by the planner. Those will all be conditions of approval in this instance. The lots are largely conforming, except for the variance relief that was identified to you before, which now largely goes away, except for the rear yard. For the new rear yard on 3.1.01, it will still need relief of the 18 feet pre-existing for the 30 feet required. I don't know that you need any other relief then as a result of that.
Don't they still need relief on the side?
On the front yard, setback, if you will, because they're not going.
If we're gonna,
The proposal also is to leave that, so they're going to need front yard setback relief there, but the cap variance is no longer
No.
needed, so you really have keep the existing porch on 3.0.
we still need the cap though.
Yeah, you still need the cap you need,
Oh, that's right.
regardless, you need the cap.
I'm sorry.
And
So it is.
We may need whatever that, zoning because of the corner facing not the shorter side. The front
Okay.
facing not the shorter side as well.
So they're still gonna need the cap relief. That was the discussion that you had before, where the maximum floor area is 27.86 and the requirement is 22. Again, technically a pre-existing, but because of the lot line creating that situation. We would incorporate all the conditions of approval that we discussed and also the standard conditions of approval by way of, and as we discussed also, that if they were granted this variance relief, they can build what they need to build and keep what they need to keep without coming back to for additional variance relief.
Are you going to include the dry wells that we?
Yes, all of those, the applicant has testified they're going to do that, and that was the purpose of, rather than reading through into the record all of those, the applicants basically said that they're going to with regard to dry wells. Yes, to the extent that on the existing property, if they make an appropriate submission to our engineer and the engineer agrees that it's not necessary, that's fine. But if our engineer says, no, it's necessary, they're going to comply with that. Same thing with regard to the curbs, same thing with regard to the sidewalks, same thing with regard to placing utilities and separate services underground, trying to coordinate, as we had a discussion before with regard to what's presently happening.
Grading?
They're going to be doing grading one way or the other. Right. Again, they're going to have to submit that to our engineer for their approval to make sure that they're not adversely impacting any drainage at the site. They're going to have to comply with the tree removal ordinances. They're going to have to get the will serve letters. They're going to have to, they're gonna have to make some modifications, make sure that they know that they're on Parker Avenue as opposed to Parker Street. And as I say, that's not to the exclusion of any of the conditions that were placed in the plan. A positive vote is a yes vote. There is a yes, this can go forward. A no vote is a no, not go forward.
Doug, can I just confirm one thing?
Sure.
Just for the board. What you're voting on is a subdivision. They're looking to keep the existing house. Once it gets subdivided, the applicant can come into the zoning officer and ask for a demolition permit.
But he
For that,
right, but he will not be able to ask for any variance for the
Correct.
appraisals.
so I just wanted to let, just to
But
confirm.
you won't be able to.
Yeah, but
Ask for any additional variances, you're gonna have to go conform. The way we're going to craft this resolution is that as proposed, the applicant will not need to have any additional variance.
The new proposed structure will not require any variances. That
Correct.
will be fully compliant.
The new structure that they're going to build on lot 3.01 has to be compliant.
Go to.
That keeps the board, and I'm not casting any aspersion, that keeps the board from getting whipsawed. If the person takes this application,
Yeah.
packages this application, says, great,
Uh-huh.
I'm selling it.
Yeah.
I'm selling it. Now you develop, a new developer comes in, I need the variances. The way we're going to craft this resolution is, you know, you made representation that you can build what you want to build, keep what you want to keep without additional variances from this board.
Including existing, right? So if they knock down existing, they'd have to build.
They'd have to build.
Correct.
Correct.
And that's why that extra 6 feet is important, because it gives them.
I'm just framing the resolution, not opening it back up to discussion.
Okay, got it,
And you can certainly make that comment at the time of your vote.
right, exactly.
Okay? Now I have a first, put the motion before you, doesn't mean, if you say yes, it doesn't mean you have to vote for it. It just puts it before the board so that action can be taken. And I have a motion,
I'll make a motion.
second,
I'll second.
okay, do you have that, Sheila? Okay, roll call,
Mr. Bordelon,
Yes.
Mrs. Bush.
Yes.
Mrs. Koch,
No,
Mr. Newell,
Yes.
Mrs. Antonin,
No.
Mr. Bailey,
Yes.
Mr. Fletcher.
yes. Application carries,
Thank you very much.
congratulations.
good luck.
Thank you.
Yeah.
That's no-
Okay. We do have a couple minutes to scramble, then we have other business before the board.
Yep.
Still have other things to do.
Have a good night.
Okay. Administrative items.
Approval of minutes from January 16th, 2024. Have you guys had a chance to look through them? If I get a motion to approve,
Motion,
Ms. Scotch?
second,
No. Roll call.
Bush,
Yeah.
Koch,
yes.
hey, I couldn't hear you. Hey, yes, sorry.
Mrs. Antonin,
Yes.
Mr. Bailey,
Yes.
and Mr. Fletcher.
Yes.
Okay, then I guess, yep, we need approval of the executive session minutes from January 16th.
Motion,
Second.
Mrs. Bush,
Yes.
Koch,
yes.
Mr. Newell,
Yes.
Mrs. Antonin,
Yes.
Mr. Bailey,
Yes.
and Mr. Fletcher.
Yes.
Yeah, then the next two are a resolution. Can you do these the same? Okay.
You can do these combined, you can do it. Consent agenda for C and D for resolution authorizing contract with board attorney and board planner for 2024.
Motion,
Second,
Second.
Mr. Bordelon,
Yes.
Mrs. Bush,
Yes.
Mrs. Koch,
yes.
Mr. Newell.
yes.
Mrs. Antonin,
Yes.
Mr. Bailey,
Yes.
Mr. Fletcher.
Yes.
Sheila, just to confirm, you have both of those contracts, right?
I do.
Okay. We're gonna open up the public comment.
No more public comment?
Close public. Anything else?
Motion to adjourn? Okay. Just kill the recording and we're done. I don't know what these guys is.
I've been a timer.
So, we.